There's coverage under under CGL policy for a data breach and lost information. And you say to yourself, how can that be? People said to us yesterday in the conventional wisdoms, there's no coverage here. We didn't mean to cover that as the insurers, right? We didn't want to cover data breaches. We wrote the insurance policies on which these are based in the 1930s. We did it when we called it a comprehensive policy and haven't really changed the definition of personal advertising injury that greatly. Excuse me, that's what it's designed to cover, and let me tell you why. Courts have found that it is covered. And so you heard Peter mention that he's gotten coverage under personal and advertising injury coverage under a CGL policy for data breaches. I've advised clients and gotten them to put people on notice and gotten coverage for this very thing. And you think to yourself, how can that be? Well, let me draw you a parallel because there's not a lot of case law on this question. Let me talk to you about Zurich American versus Fieldstone mortgage case. So how many of you got phone calls during the bubble in which you got a call from a mortgage broker saying, I can get you a lower rate on your mortgage because everyone was making money on mortgages then, right? How many of those calls were probably based upon viewing of your credit record and knowing that you probably have sterling credit records and that they, of course, want to cover you rather than someone who is a subprime risk? Did you know that that's not allowed under the Fair Credit Reporting Act to take a look at your credit record without prior authorization? And you're thinking to yourself, how in the hell does this relate to data breaches? So here's someone who gets a phone call, and they say, we'll get you a better mortgage rate, and turns out they looked at his credit report. And he's enterprising. And he says, I'm going to sue you for having violated the Fair Credit Reporting Act. Fieldstone Mortgage gets sued, and it goes to its CGL carrier and says, please, Zurich, would you cover us for this claim? And Zurich says, no, we will not cover you for this claim because CGL policies don't cover things like improperly viewing a credit report. So Zurich argues that in order to constitute publication, the information that violates the right to privacy must be divulged to a third party. So what? In a newspaper, on a billboard, on a party conference call, they have to publish it online, right? That's what it means. That's what we all think in the insurance industry. Publication, it's got to be in a book someplace. Wrong. Court says, quote, the majority of courts have found that the publication need not be to a third party. And here's the payoff. What is a data breach? What's a data breach? Someone looks at information that they shouldn't see, and it does not have to be to a third party. If I look at a credit report without prior authorization, and that's personal and advertising injury coverage, if I look at data that's supposed to be private, and I tell someone else or I know on my own, is that not the same thing? Rick's going to say no. I say that it is. Now, the District Court of Maryland has found that. We know that's not the Supreme Court. Other courts have followed it. If you have a data breach loss and you've got personal advertising injury coverage, you should, at a bare minimum, put the insurer on notice. And perpetual storage, if you haven't hired counsel, take this note. You should make this argument. And University of Utah, you should make this argument that it is covered under personal advertising injury.
Let me disabuse you of any of these fantasies that certain judges have. But it's not good law. It is not a majority of courts that say that. There has to be prerequisites, predicates to coverage, one of them being publication. Now, some courts, admittedly, read publication to mean a very narrow description or a narrow disclosure of information, including to perhaps the person about which the information is spoken. For example, Texas has a self-publication rule. Believe it or not, you can be defamed in Texas if someone tells you something bad about yourself. In Texas, there can be self-publication for defamation. Does that make any sense to anybody? No, of course not.
It does to me.